The Valley Current.
So I want you to imagine walking into the United States Supreme Court. Like, really picture it.
Oh, the highest court in the land, the marble, the whole thing.
Right. The absolute pinnacle of American jurisprudence. You have 9 justices in black robes sitting beneath these massive marble friezes, gravely and intensely debating a rubber dog toy.
A dog toy that literally says 43% POO BYVOL.
Yes. It's the absolute definition of surreal.
It really is. It's asymmetric warfare at its most bizarre. The majesty of the Supreme Court trying to parse the legal ramifications of canine excrement puns.
Exactly. So today we are dissecting this 12-year, multi-million-dollar legal bloodbath. And it's between a scatological squeaky toy and a 150-year-old American whiskey empire.
Which is just a wild sentence to say out loud.
It really is. But we're pulling our insights today from this incredible piece of analysis. It's an August 2026 technology and IP briefing authored by Jack Russo of Computer Law Group, LLP.
It's a fantastic brief.
Yeah, it really breaks it down. And the mission of this deep dive is to explore that crazy intersection of law, parody, and just sheer unadulterated stubbornness. Really trying to answer the central question that the briefing poses, which is, does persistence actually matter in federal intellectual property litigation?
And, well, spoiler alert for the listener, it matters more than almost any other variable.
Yeah.
I mean, stamina is basically a currency all its own in the legal system.
Right. So whether you are an entrepreneur trying to protect a new idea or, a creator who makes a living through parody, or honestly just someone who loves a truly wild David versus Goliath story, this deep dive is going to reveal a lot.
Oh, absolutely. The hidden economics, the psychological toll.
Yeah, the toll required to survive a decade-long corporate battle. Because, as we're going to see, this was never really just about a dog toy. It was about the structural limits of corporate power and, well, the actual price tag of the First Amendment.
And just how the American legal system actually functions when you fundamentally refuse to quit.
Exactly. So to really understand how a poop joke ends up at the Supreme Court, we first have to set the board right.
Right. We need to look at who is actually fighting. And crucially, the specific legal weapons they brought into the arena.
Okay, let's start with Goliath. Jack Daniels. I mean, this isn't just a successful company. This is a foundational piece of American commerce.
Oh, yeah. A total juggernaut.
We are talking about a brand with continuous, registered trademark use dating all the way back to 1875. They survived Prohibition. They survived multiple world wars. They've been the best-selling American whiskey since, 1997?
Something like that, yeah.
Yeah.
And they are armed with that iconic old number 7 mark, plus that instantly recognizable trade dress.
The black label, the white filigree lettering, the square bottle. You see it from across a crowded bar and you instantly know what it is.
And the cultural weight of that trade dress, I mean, it really cannot be overstated. When a corporation spends a century and a half and likely billions of dollars in marketing, cementing a very specific visual identity into the minds of the global public, they protect it.
Ferocious.
Exactly. With a ferocity that borders on the religious. And they kind of have to. In trademark law, if you don't aggressively police your borders, you risk losing your territory entirely.
Which brings us to David in this scenario. A company called VIP Products.
Right, out of Arizona.
Yep, an Arizona toy company run by an entrepreneur named Steven Sacra. And their entire business model, or at least a very lucrative part of it, is based on a line of parody items called silly squeakers.
They have a very specific somewhat sophomoric comedic niche.
Extremely specific. I was reading through their catalog, and they've released toys like Smella Arpaw instead of Stella Artois,
right?
Doggy Walker instead of Johnny Walker, and Heine Sniffin instead of Heineken.
Classy stuff.
Well, very highbrow. But the product that triggered the specific 12-year war was called Bad Spaniels. It's a squeaky dog toy shaped exactly like a classic Jack Daniels bottle. But, they tweaked the label.
They definitely tweaked it.
So instead of Old Num 7, the toy says the Old Num 2 on your Tennessee carpet. Instead of 40% alcohol, it boasts 43% POO BYVOL. And right at the bottom, just to drive the point home, it proudly declares it is 100% smelly.
So you can imagine, Jack Daniels executives see this product on the market, and they do not find it funny at all. So in 2014, they send a cease and desist letter. They basically demand VIP stop selling the toy immediately, assuming the small company will just, fold.
Because that's what usually happens. The giant roars, the small company runs away, but VIP doesn't fold. In fact, VIP does something incredibly aggressive. They sue first.
Yeah, that was a huge move.
The brief notes that VIP sought a declaratory judgment. Now, for the listener who might not be a lawyer, let's explain that. A declaratory judgment is basically a preemptive strike. Right?
Exactly. It's when you go to a judge and say, hey, this giant company is threatening to sue me, but I don't think I'm breaking the law. I want you, the judge, to officially declare that my dog toy is perfectly legal, so they have to leave me alone.
It's a really bold move. You are forcing the issue. But by doing that, VIP essentially dared Jack Daniels to unleash the Kraken.
And Jack Daniels did. They countersued under the Lanham Act, which is the primary federal trademark statute in the United States.
Yeah.
And they didn't just throw generic complaints at the wall. They used two very distinct legal theories: infringement and dilution.
Okay, let's unpack this, because understanding the difference between those two things is the skeleton key to this entire 12-year case. The first weapon is infringement.
Right.
From my understanding of the briefing, infringement is entirely about protecting the consumer. Like, the law doesn't want you going to the liquor store, buying a bottle of what you think is Jack Daniels, taking a sip, and realizing it's actually, I don't know, terrible dog toy juice.
Well, hopefully you wouldn't find dog toy juice at a liquor store. But yes, that is exactly right. It protects the source identifier so that consumers are not confused about what they're actually buying.
So it's all about deception.
Infringement requires proving a likelihood of confusion. Does a reasonably prudent consumer look at the Bad Spaniel's toy and genuinely believe Jack Daniels manufactured it or endorsed it?
Okay, but Jack Daniels didn't stop at infringement. They deployed the heavy artillery, which is dilution. And dilution is fascinating because it doesn't care about consumer confusion at all, does it?
Not even a little bit. Dilution is about protecting the sheer power and the aura of the brand itself. But because it is such a massive legal weapon, I mean, it essentially allows a company to monopolize a word or image across completely unrelated industries. The law heavily restricts it.
Right. You can't just throw dilution at anyone.
Exactly. You can only claim dilution if your mark is so famous it qualifies as a genuine household name.
And the brief actually notes that dilution breaks down into two distinct subcategories. The first is blurring.
Blurring, yeah.
So blurring is when someone chips away at the distinctiveness of your mark. Like if I started selling, say, Jack Daniels brand pianos.
Right. Nobody's confused by that.
Yeah. Nobody thinks the whiskey distillery is suddenly making grand pianos. But over time, if people see Jack Daniels pianos, Jack Daniels lawnmowers, and like Jack Daniels running shoes, the name loses its singular, unique association with premium whiskey. The identity blurs.
Exactly. But blowing wasn't the primary battlefield here. The second form of dilution is what this entire 12-year war was fought over, and that is tarnishment.
Tarnishment.
Tarnishment occurs when a junior user links the famous mark to something unsavory, degrading, or just unwholesome. And by doing that, they harm the famous mark's reputation.
Okay, let me try out an analogy here to make sure we are drawing the line clearly between infringement and tarnishment. Tell me if this tracks. Let's imagine we are at a massive, high-end corporate networking event.
Okay, picturing it.
Infringement is like someone stealing my literal name tag, pinning it to their own lapel, and walking around shaking hands. They are actively tricking the people in the room, the consumers, into thinking they are me.
That's classic infringement. Direct consumer deception.
Right. But tarnishment is totally different. Tarnishment is like if I am standing there wearing my own name tag, minding my own business, and someone walks up and intentionally dumps a giant, foul-smelling, sticky garbage drink right over my tailored suit.
Oh, wow. Okay.
Now, nobody in that room is confused about who I am. My name tag is still right there, but everyone looking at me thinks, wow, that person looks disgusting.
Right. They associate you with the garbage.
Exactly. My reputation in the room is completely ruined, not by confusion, but by association with this gross thing.
That is a phenomenal analogy. I mean, you've captured the exact essence of the statute. Jack Daniels' argument was essentially, hey, we sell a premium beverage meant for human consumption. VIP products is forcibly linking our visual identity to literal canine excrement.
They are throwing a sticky garbage drink on their tailored suit.
Exactly. And they argued that it inherently damages their 150-year-old prestige.
So the battle lines are drawn. VIP says it's a harmless joke. Jack Daniels says it's reputational vandalism. But how does a fight over a squeaky toy drag on for 12 agonizing years?
Well, that's where it gets really procedural and messy.
The briefing maps out this procedural flowchart that looks like a tangled ball of yarn. It's a literal 5-round prize fight. And tracing this timeline is so important because it really shows the sheer grinding procedural exhaustion involved in federal litigation.
It really does. Because, people often think of a lawsuit as a single event. Like you go to court, a judge bangs a gavel, somebody wins, and you all go home.
Right, like an episode of Law and Order.
Exactly. But in federal intellectual property litigation, a trial is often just the opening ceremony.
Okay, let's start the clock on round 1. It is 2017. 3 years after the initial cease and desist letter, we are in the trial court, specifically the District Court of Arizona. Judge Stephen M. McNamee is presiding over a bench trial.
And just to clarify for the listener, a bench trial means there is no jury.
Right, so the judge is acting as both the referee of the law and the finder of fact. So what happens in 2017?
VIP Products gets completely steamrolled, just a total defeat. Judge McNamee finds them liable for both infringement, meaning he actually bought the argument that consumers might be confused, and tarnishment. And consequently, he issues a permanent injunction.
A permanent injunction, which means the toy is legally banned from being manufactured or sold. Jack Daniel's wins by knockout in the very first round.
Yeah, it seems like it was over.
And honestly, I try to put myself in the shoes of Steven Sacra, the toy company owner, at this exact moment. You've already spent 3 years of your life and likely hundreds of thousands of dollars in legal fees defending a plastic joke.
A literal poop joke.
Right. And a federal judge just looked down from the bench, told you that you are a trademark infringer, a brand tarnisher, and ordered you to pull your product. I feel like 99% of sane business owners would just pack it in right here, cut their losses, and move on to the next toy.
Oh, absolutely. The economic and psychological pressure to surrender after a permanent injunction is immense. You have had your day in court, you lost. The system is designed to make you feel like the matter is definitively settled.
But survival isn't the same as a legal victory. VIP doesn't stock, they appeal. Which brings us to round 2.
Round 2, the year is 2020.
Right, 2020. The venue is the Ninth Circuit Court of Appeals. And we get our first massive whiplash of the saga. VIP wins.
They do. And they don't just win, they get the injunction completely thrown out. The Ninth Circuit panel looks at the case and says, hold on, we need to view this through the lens of the First Amendment.
Wait, really? A dog toy gets First Amendment protection?
Yes. They determine that the dog toy is an expressive work. It is communicating a humorous message. Because of that, they apply something called the Rogers Framework.
Okay, the Rogers Framework, the brief mentions this extensively. Explain the mechanics of this, because it sounds like a legal force field.
It essentially is a force field. The Rogers Framework comes from a famous 1989 case involving the actress Ginger Rogers. Someone made a movie titled Ginger and Fred, and she sued, saying they were using her name to sell the film. But the court ruled that when you are dealing with an expressive artistic work, like a movie, a book, or in this case, a parody dog toy, the First Amendment gives you massive latitude.
Because it's art, or at least expression.
Exactly. Under Rogers, as long as the use of the trademark has some minimal artistic relevance to the work, and it doesn't explicitly mislead the consumer, it is fully protected speech.
So the Ninth Circuit basically draped the Bad Spaniels toy in the armor of the Constitution.
Pretty much.
And not only that, the brief notes they also found the toy fell under a statutory exclusion for non-commercial use, meaning because it was a parody, it was exempt from the dilution statute entirely.
Precisely. The appellate court says parody is protected commentary. The dog toy is back on the shelves.
I can just imagine VIP popping champagne. But Jack Daniel's is a Goliath for a reason. Goliaths do not take a punch, stay on the mat, and accept that a dog toy just created a massive loophole in their trademark enforcement strategy.
No, they do not.
They appeal to the ultimate boss level. Round 3. The year is 2023. The United States Supreme Court.
And this is where the entire landscape of American trademark law violently shifts. The Supreme Court issues a 9-0 unanimous victory for Jack Daniel's.
Unanimous. I mean, in a highly divided, highly partisan, modern Supreme Court, getting a 9-0 ruling on anything is a staggering achievement. Why did the justices side with the whiskey company so definitively?
Well, Justice Lena Kagan wrote the opinion, and her reasoning was laser-focused on the specific mechanics of how VIP was using the joke. She didn't say parody is dead.
Okay, so you can still parody things.
Right. What she said was if you use a trademark as a source identifier, meaning you are using the joke as your actual brand name to sell a physical product in the commercial marketplace, you do not get to use the Rogers free speech test as an automatic shield.
Ah, I see. So there is a difference between like a comedian making a joke about Jack Daniel's in a stand-up special and a company slapping a joke onto a product and using that joke as their brand name.
Exactly. Kagan's logic is that the moment you use the parody to identify the source of your own commercial goods, you have entered the marketplace. And in the marketplace, you play by standard commercial trademark rules. You don't get a First Amendment get-out-of-jail-free card just because you're being funny.
Okay, so what happens mechanically at this point? Because the Supreme Court doesn't hold a new trial, right?
No, they don't do trials.
The brief says the case was vacated and remanded.
Right. Vacated means the Supreme Court legally erased the Ninth Circuit's 2020 victory for the dog toy. It's just gone.
Wiped from the record.
Exactly. And remanded means they sent the case all the way back down the ladder to the lower courts with a note saying, basically, you used the wrong legal framework, do the entire standard trademark analysis over again from scratch, but this time you cannot use the First Amendment as a shortcut.
Which drags everyone, kicking and screaming, back to round 4. We are back in the district court on remand. It is now 2025.
We are 11 years into this dispute.
11 years. We are back in front of Judge McNamee, the trial judge who banned the toy the very first time. He looks at the case again, stripped of its First Amendment armor. So what does he do?
He issues what amounts to a split decision. On the one hand, he reverses his original stance on infringement. He acknowledges that, okay, upon closer look, it is an obvious parody. Consumers aren't actually going to be confused into thinking Jack Daniels makes dog toys.
Well, that's a relief. So VIP wins on infringement.
They do. But there's always a but.
But he doubles down on tarnishment. He reiterates that the poop joke still inherently damages Jack Daniels' premium reputation. And so, for the second time in a decade, he issues a permanent injunction banning the toy.
The emotional whiplash is just unbelievable. I mean, imagine the roller coaster VIP Products has been on. They lost at trial. They won on appeal. They got completely crushed 9-0 at the Supreme Court. And now they just lost again at the trial court. It's 2025. They've been paying lawyers for 11 years. And they are staring at another permanent ban.
It's grueling. But what do? They authorize another appeal. Round 5, August 4, 2026. Back to the Ninth Circuit.
And this is the climax of Jack Russo's briefing. A unanimous 3-judge panel for the Ninth Circuit vacates the tarnishment claim completely and directs a final judgment in favor of VIP Products. After 12 years, the dog toy finally, definitively wins the war.
Wow. And this is where Russo's core thesis really shines, I think. Look at that timeline. 2014 to 2026. Look at the procedural ping pong. Every single transition from one court to the next over those 12 years only exists because the loser of the previous round categorically refused to stop fighting.
It is staggering. I mean, think about it. If VIP gave up in 2018 after the first injunction, they would be a forgotten footnote.
Yep.
If Jack Daniels gave up in 2020 after the Ninth Circuit ruled against them the first time, the Supreme Court's monumental 2023 ruling on source identifiers, which is now foundational trademark law for the entire country, would never have happened.
It's like the butterfly effect, but fueled by billable hours.
That's exactly what it is.
The entire landscape of modern trademark law literally only looks the way it does today because these two specific companies stubbornly refuse to accept defeat.
Exactly.
So VIP bought themselves another round in court, and it ultimately paid off. But to actually win in 2026, they couldn't just rely on free speech anymore, right? The Supreme Court took that shield away.
Right, they had to fight on the merits.
And the Ninth Circuit didn't just hand VIP a polite victory. They systematically dismantled Jack Daniels' legal arguments. So how exactly did the dog toy win on the strict letter of the law?
They won by weaponizing the very specific mechanics of the dilution statute. Remember earlier when we said dilution requires a mark to be a household name?
Right. It's a super high bar because it's such a powerful weapon.
Exactly. In 2006, Congress passed the Trademark Dilution Revision Act, which demands incredibly strict, rigorous proof of that fame. What the Ninth Circuit found in 2026 was that the trial judge had made a fatal mechanical error by grouping all of Jack Daniels' brand elements together into one big bucket of fame.
They treated it like a fast food combo meal instead of evaluating the items a la carte.
Precisely. The appellate panel said, no, you have to prove fame mark by mark, individual element by individual element. And when they separated them out, they found that while the words Jack Daniels and the square bottle design cleared the household name bar, the specific phrase, Old Number 7, did not clear that bar on its own.
Okay, wait. I have to pause you there and push back on this. How can Old Number 7 not be famous? It is printed on every T-shirt and every dive bar in America. It is synonymous with the brand. I feel like my grandmother knows what Old Number 7 is. Isn't this just a convenient legal loophole? Isn't the court just ignoring reality to save a dog toy?
I know. It sounds counterintuitive, but it perfectly illustrates the chasm between cultural popularity and statutory legal fame. Under the dilution statute, a mark must be widely recognized by the general consuming public of the United States as a designation of source. It's essentially asking this. If you completely divorce the phrase Old Number 7 from the Jack Daniels name and remove it from the square bottle and just write it in plain font on a blank piece of paper, does the entire American public instantly know it means whiskey?
Well, when you put it like that, probably not. Without the context of the bottle and the main logo, it's just a number. It could be like a deli sandwich number or a racing number.
Exactly. The court said Jack Daniels failed to provide enough empirical hard evidence to prove that the isolated standalone phrase Old Number 7 achieved that astronomical level of independent fame. And here's why that legal technicality is utterly devastating for Jack Daniels' case. VIP's primary joke on the bottle wasn't that Jack Daniels is poop.
Right. The joke was the Old Number 2.
Yes, it was a direct pun on Old Number 7.
Oh, that is brilliant lawyering. If Old Number 7 isn't legally famous enough to be protected from dilution, then parodying it with Old Number 2 drops out of the legal analysis entirely.
Completely drops out.
You literally cannot tarnish a mark that doesn't qualify for tarnishment protection in the first place.
Exactly. A massive chunk of the plaintiff's case simply evaporated like smoke because they failed to meet the strict statutory burden of proof for that specific mark.
Okay, that is a masterclass in dissecting a claim. But what about the rest of the bottle? Because the shape, the main logo, those were deemed famous, right?
So those cleared the bar.
So how did VIP defeat the tarnishment claim for the elements that did qualify?
That brings us to one of the most fascinating evidentiary failures in recent IP history, dealing with the psychology of disgust.
The psychology of disgust. Okay, I'm listening.
So Jack Daniels knew they had to prove to the court that the dog toy actually tangibly harmed their reputation.
Yeah.
So they brought in a heavy hitter, an expert witness named Dr. Idemar Simonson.
And the brief mentions Dr. Simonson relied on something called the associative network model, which, from my reading, he's basically arguing that the human brain operates like a massive web of linked ideas and memories.
Yes, exactly.
So if you force a link between a premium whiskey and, well, dog poop, that neural pathway gets contaminated. The disgust of the poop subconsciously travels down the web and attaches to the whiskey. Did the court buy that web analogy?
They absolutely did not.
Really?
No. While the theory sounds incredibly persuasive in an academic vacuum, the Ninth Circuit identified a fatal, gaping hole in his methodology. Dr. Simonson never actually studied the Bad Spaniel's toy itself.
Wait, what? He was testifying in a trial about a specific toy, and he didn't use the product in his research.
He ran no empirical studies, no focus groups, no surveys on how actual consumers reacted to this specific dog toy. He just applied generic, abstract psychological theory about how disgust works.
Wow.
Yeah. The Ninth Circuit threw his testimony out entirely, labeling it pure conjecture. They established a massive precedent here. You cannot use generalized psychological theory to prove a specific legal harm. You have to prove that this specific squeaky toy caused this specific reputational damage.
That is amazing. He basically walked into federal court and said, well, poop is gross, whiskey is good, therefore toy is bad. And the court said, show your math.
And because he couldn't, his entire testimony collapsed. He couldn't show the math for how a self-evident joke generates the same visceral disgust that those words might cause if they were printed on, say, a bottle of actual liquid meant for human consumption. Context matters deeply.
And speaking of context, the brief highlights how the Ninth Circuit treated the concept of parody itself. Because back in 2023, the Supreme Court said parody wasn't a statutory get-out-of-jail-free card. But in 2026, the Ninth Circuit ruled that parody is still absolutely vital context that cannot be ignored.
Yes. The Ninth Circuit joined several other heavy-hitting circuits, like the 2nd, 4th, and 10th, in ruling that even if a parody doesn't give you automatic immunity, the fact that a product is an obvious joke is highly relevant evidentiary context.
Because it changes how you perceive it.
Exactly. Why? Because an obvious joke proves that consumers are experiencing commentary, not contamination.
Commentary, not contamination. I really love that phrasing. It explains the mechanics of the humor.
Exactly. If a consumer looks at the Bad Spaniel's toy, recognizes the visual reference to Jack Daniels, but instantly realizes it's a joke mocking the brand, their brain categorizes the entire experience as humor.
Oh.
They don't suddenly think Jack Daniel's is a dirty company that makes poop water.
Right. They think, oh, that's a funny, slightly gross toy making fun of Jack Daniel's.
Exactly. Ignoring the mechanics of the joke, the Ninth Circuit said, was the trial judge's critical misstep. You cannot accurately analyze tarnishment without acknowledging the humor.
So VIP completely runs the table here. They dismantle the fame argument mark by mark, they invalidate the psychology expert for lack of empirical data, and they successfully weaponize the context of parody to prove commentary over contamination.
It was a very comprehensive victory.
But, and this is the harshest pivot in the brief, it is wonderful to have a brilliant legal theory about parody. It is quite another thing to have the cold, hard cash required to argue that theory 5 different times in federal court over 12 years.
Oh, absolutely.
Let's look at the persistence wager. What does this kind of stamina actually cost?
Well, this is where Russo's briefing pivots from high-minded legal theory to harsh, unforgiving business reality. Persistence in the American legal system is not just a moral virtue. It is a financed bet.
Let's break down the economics because the numbers are staggering. The briefing cites data from the 2023 American Intellectual Property Law Association, the AIPLA Economic Survey. It breaks down the median costs of litigating an IP case through appeal. Let's start with the lower end. Say you are fighting over a relatively small claim. There is under $1 million at stake. What is the median cost to fight that?
Roughly $600,000 per patent or trademark.
$600,000 for a case worth less than $1 million. You're spending 60% of the disputed value just to pay the lawyers. That is a brutal ratio.
It really is.
But what if it's a massive corporate fight? What if the stakes are over $25 million?
Then the median cost skyrockets to $3.625 million. And I really need to emphasize, that is per mark. If you are fighting over multiple trademarks in a single suit, you multiply that number.
So let's put this in perspective. You are Steven Sacra at VIP Products. You are selling a rubber dog toy that probably retails for, what, 15 or 20 bucks at Petco?
Sounds about right.
You are facing millions of dollars in legal fees just for the privilege of standing in the courtroom to defend your pun. That is what Russo means by a financed bet.
And money is only one currency you are burning. The other currency is time.
Right.
The briefing points out that it takes, on average, 2.4 to 2.8 years just to reach a trial in U.S. IP cases.
Yeah.
That is years of discovery, which is the agonizing process of turning over all your internal emails and documents to the other side.
That's exhausting.
It is. Years of depositions, years of motions, and years of uncertainty hanging over your business before you ever step in front of a judge for a final decision.
It's no wonder the briefing notes that over 75% of IP cases settle before trial. The friction is just too high. You get financially and emotionally ground into dust.
The system is structurally designed to encourage settlement because the alternative is economic exhaustion.
I want to talk about the odds of actually winning on appeal because this statistic blew my mind. I want you, the listener, to imagine being the CEO of a company. Your general counsel walks into your office. You just lost at the trial court. You have to decide whether to authorize a massive multi-million-dollar budget for an appeal. What are the actual mathematical odds that you will win?
The math is terrifying. According to the briefing, the Federal Circuit affirms lower court decisions roughly 73% of the time.
73%, wow.
Now, that number fluctuates a bit year to year. It was 76% in 2023, dropped to 57% in 2022. But historically, the overwhelming majority of the time, the appellate court simply looks at the trial judge's work and says, yep, looks good to us. Full reversals or vacatures only happen about 20% of the time.
So it's like walking up to a roulette table in a casino where 73% of the slots are painted house green, and you have to pay $3.6 million just for the privilege of spinning the wheel.
That's a great way to put it.
You are paying millions of dollars and waiting years for a 1 in 5 shot at reversing a loss.
Which is why Russo makes such a profound point in the briefing. Persistence isn't a virtue in a vacuum. It is a purchased option. VIP Products basically bought the optionality to still be standing in the arena when the law finally shifted in their favor. They paid a massive premium to stay at the table long enough to draw a winning hand.
But they aren't the only ones who have made this massive wager. VIP Products is not an anomaly. This exact dynamic, a smaller entity absorbing massive intermediate losses, bleeding cash, but categorically refusing to quit against a giant, is actually a documented historical pattern in IP law.
It is a structural feature of the system. The briefing includes a fascinating chart, Table 2, which showcases 16 different asymmetric IP campaigns over a 25-year period. It proves that this David versus Goliath dynamic repeats constantly.
Let's look at some of the triumphs on this list. Because when the bet pays off, it pays off in spectacular fashion. Look at NTP versus Research in Motion, the makers of the BlackBerry.
Oh, that's a classic.
This was a 5-year battle in the early 2000s. NTP was a tiny 2-person holding company with some patents. RIME was a global giant whose devices were in the pocket of every politician and CEO on Earth.
Right. Everyone had a BlackBerry.
Right. But NTP persisted through years of brutal litigation, held firm under the threat of an injunction that would have literally shut down the entire BlackBerry network in the U.S., and walked away with a $612.5 million settlement.
Huge. Or look at I4I versus Microsoft. A small tech firm out of Toronto fought Microsoft from 2007 to 2011 over XML formatting in Microsoft Word. They took it all the way to the Supreme Court.
A small Toronto firm taking on Microsoft.
Exactly. Microsoft tried to get the standard of evidence changed to make it easier to invalidate patents, but I4I fought them and won, preserving what we call the clear and convincing evidence standard.
Real quick, define the clear and convincing evidence standard for the listener.
It's a very high burden of proof. It means the evidence presented by a party must be highly and substantially more likely to be true than not. Microsoft wanted a lower standard, a simple preponderance of the evidence, making it easier to kill I4I's patent. But I4I held the line at the Supreme Court and secured a $290 million judgment.
Incredible.
Yeah, these are monumental victories that only happened because the smaller party refused to fold when staring down a titan.
And I want to emphasize this because the briefing is very careful not to romanticize blind persistence. Stamina does not magically fix a bad claim. There are cautionary tales on this list that are absolutely chilling.
Yes, persistence can just as easily lead you right off a cliff. The briefing highlights VernetX versus Apple. VernetX fought Apple for 14 years. 14 years of relentless litigation over secure communication protocols. They won a massive $502.8 million jury verdict.
$500 million. You win that, you think you're retiring to a private island.
You'd think. But Apple didn't quit either. Apple dragged it out, went to the Patent Trial and Appeal Board, the PT, an administrative board that reviews patent validity, and managed to get the underlying patent invalidated.
Oh, no.
Because the foundation was wiped out, that entire $500 million verdict was vacated. It vanished.
It's like spending 14 years building a massive, beautiful mansion only to have the city condemn the dirt it was built on. 14 years of your life, millions in legal fees, you hold a $500 million winning lottery ticket, and it turns to ash in your hands.
It's devastating. And we see the same cautionary tale with Sonos versus Google. Sonos won a $32.5 million verdict, only to have the judge set it aside for issues regarding latches.
Latches. That's a great legal term. From my understanding, latches is basically the legal version of you snooze, you lose. Or maybe more accurately, waiting in the bushes. It means you waited an unreasonably long time to sue someone, allowing them to build up their business. And because of your deliberate delay, it's no longer fair to punish them.
That's a great way to put it. The judge found Sonos waited too long to assert its claims, effectively sandbagging Google. That case is now grinding through the federal circuit. But the ultimate lesson of Table 2 is that grit cannot overcome a fundamentally flawed legal position. You can't outlast bad facts.
So if you are a founder or a CEO or just a professional making tough strategic calls in your own life, how do you synthesize this? Because the business decision of knowing when to cut your losses versus when to double down against overwhelming odds is agonizing.
It is the ultimate executive test. The briefing intentionally withheld calibrated judgment on whether VIP's 12-year, multi-million-dollar war over a squeaky toy was actually worth it from a pure return on investment perspective. We don't have access to VIP's internal financials. We don't know how much they paid their lawyers versus how much they made selling bad spaniels.
But we can deduce their strategy. They made a calculated assessment that their core business model parody products was facing an existential threat. If they lost this case, Jack Daniels or any other big brand could shut down every single silly squeaker toy they made. They couldn't just walk away. They had to bet the house.
They bought the option, and the option paid out. But what makes this case truly legendary is that they didn't just win a statutory victory on the technicalities of trademark fame. They actually set a trap for the future.
Which brings us to the final and perhaps most consequential part of our deep dive, the unfinished business. VIP won the battle, but they intentionally left a massive constitutional time bomb ticking in the background for the next litigant to detonate.
Oh, this is the best part. VIP didn't just argue that Jack Daniels failed to prove tarnishment under the statute.
Yeah.
They argued that the federal tarnishment provision is, in and of itself, facially unconstitutional under the First Amendment.
Let's really dig into this. How can a major federal trademark law, one that has been on the books for years, be unconstitutional?
Well, VIP argued that the tarnishment statute essentially allows massive corporations to use the power of the federal government to suppress unflattering speech about big brands. Think about the mechanics of it. By definition, tarnishment punishes someone for associating a famous mark with something unsavory. But in the context of parody, associating a pristine brand with something unsavory is the entire point of the joke.
It's a juxtaposition that makes it funny.
Exactly.
Yeah.
VIP argued that treating laughter as legal injury is a fundamental violation of free speech. They are essentially saying the Lanham Act is acting as a corporate blasphemy law.
A corporate blasphemy law. Wow.
Yeah, it punishes viewpoint-specific speech. If you say something nice about Jack Daniels, it's fine. If you mock them with poop jokes, you get hit with a federal injunction for tarnishment.
That is a wildly compelling argument. So compelling, in fact, that the brief notes the U.S. government, the Department of Justice, actually had to intervene in this case to defend the constitutionality of the statute.
When the DOJ steps in, you know the stakes have transcended a dog toy.
So what did the Ninth Circuit say about this massive constitutional question? Did they strike down the tarnishment law?
They expertly sidestepped it.
Of course they did.
The court resolved the case on statutory grounds, finding that Jack Daniels failed to prove fame for old number 7 and failed to prove actual reputational harm because Dr. Simonson's testimony was pure conjecture. Because the court could resolve the dispute on those technical grounds, they declined to rule on the First Amendment issue. It is a long-standing principle of judicial restraint. Courts generally prefer not to strike down federal statutes if they can solve the case another way.
So the bomb didn't go off, but it is still sitting there, armed, waiting for someone to trip the wire.
This raises the most important question for the future, and it leads to Jack Russo's final calibrated forecast in the briefing. He predicts that this issue is not going away. If you look at recent Supreme Court history, the justices have shown a very strong willingness to strike down Lanham provisions that restrict speech based on viewpoint.
The brief specifically mentions Mattal v. Tam in 2017 and Iancu v. Brunetti in 2019. Walk us through those.
In Mattal v. Tam, an Asian American rock band called the Slants fought for the right to register their name. The trademark office had denied them under the disparagement clause, saying the name was offensive.
Right.
The Supreme Court struck that clause down, saying the government cannot ban speech just because it might offend. In Brunetti, a clothing brand named FUCT was denied registration under the Scandalous Matter clause. The Supreme Court struck that down too, again citing viewpoint discrimination.
So the Supreme Court is increasingly viewing trademark law not just as commercial regulation, but through a very strict First Amendment lens.
Correct. Because of that undeniable trend, the briefing concludes that it is highly likely a free speech challenge to the tarnishment provision will reach the Supreme Court within the next decade.
VIP products preserved that argument. They kept it alive for the next David who goes up against a Goliath. The dog toy won on a technicality, but it laid the concrete groundwork for a constitutional earthquake.
It is a perfect, striking example of how the sheer persistence of one seemingly insignificant litigant, a guy making squeaky toys in Arizona, can subtly, over 12 years, bend the long arc of constitutional law.
So, as we wrap up this incredible 12-year saga, I want to leave you, our listener, with a final thought to mull over. The next time you're walking through a pet store or scrolling online and you see a parody t-shirt or a meme mocking a massive corporation or a ridiculous squeaky joke product sitting on a shelf, ask yourself, are you just looking at a cheap $15 gag? Or are you looking at the spark of a multi-million-dollar, decade-long First Amendment war? A war that could fundamentally redefine the balance between corporate power and free speech in America. Because as we've learned today, the distance between a poop joke and the Supreme Court is a lot shorter than you think, provided you have the stamina, the capital, and the sheer stubbornness to keep walking.
Led by Jack Russo, Computer Law Group LLP is a bespoke business litigation and founder-friendly boutique law firm with offices and licensed attorneys in Silicon Valley, New York, and Tampa Bay. And you can reach Jack at jack@computerlaw.com and his team at www.computerlaw.com, where the newsletter we referred to is published in detail and readily available commitment-free with no paywalls or other charges.
Tune in next time on The Valley Current.